Hello and a warm welcome to Federal special program Capital Beat. Chief Justice of India DY Chandrachud has agreed to consider a plea urgent formation of a seven-judge constitution bench to examine the kind of bills that will be taken up by the parliament, specially categorized as money bills. Now, this comes in the wake of several allegations that NDA government has used many non-money bills as money bills in the Lok Sabha to avoid the scrutiny by the Rajya Sabha. Now, Chief Justice of India, D.Y. Chandrachud, while Mr. Kapil Sibal and Abhishek Manu Singhvi were making a mention, he happened to say that I will take the call on this when I form the constitution bench. Now, can this petition, though it's an old one, this was filed in 2014 by Congress leader Jairam Ramesh, but can this petition, once if the seven-judge constitution bench is formed, can this petition really spell trouble for the Modi government? Joining me now is veteran Supreme Court lawyer Sanjay Hegde. So thank you so much for joining. And we have Mr. PDT Achari, who's the former Secretary General to the Lok Sabha. Mr. Achari, thank you so much for joining. And begin with Mr. Sanjay Hegde, that because yesterday only Chief Justice of India has agreed to hear the plea, and he said that, okay, he will form the seven-judge constitution bench. Now, what does that mean, and how soon can this seven-judge constitution bench be formed? Because this has been pending for quite some time.
It has been pending for quite some time, and in the meanwhile, a lot of legislation has avoided scrutiny by the Rajya Sabha, especially at a point of time when the incumbent government in the early stages of its term lacked a majority in the Rajya Sabha. So matters were classified as a money bill, moved in the Lok Sabha, and thereafter there was no scrutiny by the Rajya Sabha. That had important pieces of legislation, including the Aadhaar bill, the appointment of many tribunals, all of them were using this route. That is basically a kind of fraud on the Constitution. I'm saying that in constitutional terms. The challenge has been pending, but constitution of a seven-judge bench often is difficult for not only this Chief Justice, for any Chief Justice. What people do not realize is that the personnel in the Supreme Court tend to change very fast. People are always have just come in or are on the verge of retiring. And when you get seven judges to sit on one matter for a week or two on the end, you are effectively then disrupting at least three benches of the Supreme Court. The Chief Justice on the mentioning said that he would try and constitute it. I hope he does, because even the Chief Justice Chandrachud's term ends in November. So unless he possibly talks to his successors or he fixes a very tight schedule for hearing, getting seven judges to hear the matter and to deliver a judgment before November, I would not be sanguine about it until the matter is actually listed.
But you did point out that why a seven-judge constitution bench is difficult, because you have to disrupt at least three other benches. Now, so does it mean that probably in all likelihood this seven-judge constitution bench will really not happen in this particular case? The likelihood of that is high.
No. It will happen. It has to happen someday. The question is whether it can happen immediately in the next month or so, and obviously before October, yes, so that there is a hearing and that there is time to write a judgment.
Yes.
Those are the calls. So if the Chief Justice has the personnel and is minded to do it, then it is possible. But then there are so many other matters also, all of which have demands on his time.
One quick question more to you, Mr. Hegde, and then I'll come to Mr. Achari. That now, what is going to be the order of priority when you have several other cases, and this is also equally an important matter? And as you've said, that this was a big fraud on the Constitution. if the non-money bills have been treated as money bills in Lok Sabha. So I'm sure Justice D.Y. Chandrachud is aware of the gravity of the situation and how grave this case is. So on what basis will the CJI really decide on the priority, whether it should be taken up now, whether it should be taken up maybe by the next CJI? How is he going to really prioritize?
No, no, he will only take a decision on whether it can be done in his time or not.
Okay.
That's so. Is it possible for the matter to be that he has enough judges to spare, and whether a hearing can be undertaken uh, in reasonable time and a judgment written before November? Those would be his considerations.
Okay, so it doesn't get, supposing if he's not able to take a decision, then what happens? Will the next CGI take this
Yes,
decision?
yes, it would be the next CJI or some thereafter.
Hmm.
Mr. Achari is getting bored, but let me tell you a story about me as a very young lawyer. I was sitting in court, and a very senior advocate on record, Mr. J.B. Dadachandji, mentioned a matter. See, this was in the year 1992, saying, "Your lordships may kindly list these matters which relate to the privy purses, which require a five-judge bench. These matters were tagged to the 13-judge bench of Keshavananda Bharati way back in 1973, and they have remained in for disposal for nearly 20 years. The then Chief Justice, Justice Kanya, I think it was, constituted a bench, and that's how the Privy Purses Constitution Amendment case was finally heard. So, when there is a large combination of judges to be had in the Supreme Court, it is very difficult to predict at what stage and which Chief Justice will find the time and the manpower to do.
Now I'll come to you, Mr. Achari, and coming to the bit on the non-money bills, how they were treated as money bills. Now the discretion mostly is left to the speaker, whether to intervene, whether to not to intervene. And I was just looking at the legal angles that it's the Article 110 of the Constitution that deals with the money bills as per Clause 3. Now, why do you think? Do you really suspect that the government really did so to avoid the scrutiny by the Rajya Sabha, where it didn't have the numbers? So deliberately, this was a tool which was adopted by the government. Yes, Mr. Acharya.
Well, first of all, let me say, can you hear me?
Yes, sir. Go ahead, sir. Yes.
First of all, I fail to understand why a constitution bench or seven-judge bench should be constituted for this purpose. So there is no complex legal issue involved in this. Here, Article 110 of the Constitution clearly defines a money bill. And the speaker, when he decides the issue, he cannot go outside this. He is not supposed to go. And of course, the court may decide whether the speaker has taken a proper decision on a particular matter or in case of a particular bill. That is the only thing which the court can actually decide, whether the speaker has given the right decision or taken the right decision or not. Otherwise, the definitions are very clear. For example, taxation, bill relating to taxation, bill relating to the regulation of borrowing of money, and then the custody of the Consolidated Fund of India, then the money that goes into the Consolidated Fund of India, public accounts. These are matters, which come under money bill. Now, here the most important or the key word that we should take into account is only. The word only, that is the key word. That's the limit on this issue. That is, a bill can be regarded as money bill only if it contains any of these things or all of these things. That is it. So that only word, that is the key word. And the Speaker has to look at that. If the bill contains only these provisions and matters incidental to these provisions, these are the two categories of things which come under a money bill. And anything outside that, suppose there is a bill which is a bit of a hybrid in character, a bill which contains the money bill provisions plus something else, then it is not a money bill. And that is the meaning of that word only. That is precisely what the Speaker has forgotten when he decided that issue. As Mr. Sanjay Hegde was saying, that Aadhaar is treated as a money bill, and there was an amendment to the Representation of People Act that was also termed as a money bill, certified as a money bill. Actually, the problem is under Article 110, Speaker is the sole authority to decide whether a bill is a money bill or not. The implication is very serious. You are bypassing one house of parliament. The Rajya Sabha is totally a bypass. Bypass in the sense, Rajya Sabha cannot either reject it or approve it. It can only make a recommendation. And that recommendation may be accepted or may not be accepted. So, in sum, the money bill means Lok Sabha alone has the final say and not Rajya Sabha. It can make a recommendation only. That is the point. So naturally, a political party which is in power at a particular time, if it doesn't have a majority in the Rajya Sabha, then if they think that this is the convenient route, that is a violation of the constitution. And that is precisely what the court will have to look into, whether in a particular case, whether the speaker was right or not. Because it is a constitutional provision, certainly it can be challenged.
Sorry to interrupt you, but Mr. Acharya, don't you think that this is like a tightrope walk? Because this is a speaker's discretion. Now, can you question the speaker's discretion, and will the seven-judge constitution bench, if at all, because in 2014 there was another bench which had had some doubts in their mind, and which is why Mr. Ranjan Gogoi, who in 2014 then referred the matter to the seven-judge constitution bench, which till now hasn't been formed. That is why the matter has been pending. But the speaker's discretion, how will one question the speaker's discretion? Now, say, for example, a bill like, the Aadhaar Act, then amendments to the Prevention of Money Laundering Act. I mean, these are glaring examples of how non-money bills have been converted into money bills in Lok Sabha. So how will one question now the speaker's discretion, even if the court hearing is on? Yes, Mr. Acharya.
Yes, actually not the discretion of the speaker. It's the decision taken by the speaker based on these conditions which have been listed in Article 110. And of course, it says that the speaker's decision shall be final. The word discretion is not used here. It is the speaker shall decide the issue and speaker's decision shall be final. But there are, as Mr. Sanjay Hegde knows very well, and there are many Supreme Court judgments which say that legislative finality is not a finality that is not binding on the court. Court will certainly look into things. That is the thing. So naturally, the court can look into a particular case and find out whether the speaker has given a correct decision or not. And if it is not a money bill, naturally, it will go to the Rajya Sabha and the Rajya Sabha may turn it down. All those things will happen. It is precisely to avoid that such a situation that this route was taken.
Right. Right. You make interesting points. I'll come to you, Mr. Hegde. Now, when the court starts looking into this matter, based on the various petitions and also the one which Jairam Ramesh has filed. Now, how would the court look into these issues? What are the aspects which the court will really look into? One is, of course, the speaker's decision. The other one is the examples where the non-money bills have been made into money bills. Then the intent and the motive, why the government did this. So, on the basis of that, can the court really upturn everything and just completely turn the decision upside down?
You're asking me?
Mr. Hegde, yes.
Well, the court's powers are limited, but it often applies a rule of discretion. It sometimes says that, yes, we think that all this is wrong. We strike it down. But what has happened so far, we will save. That is one route that the court can do. The other thing is, if the court says that no, all these bills which have been passed by this route are struck down and are ineffective from this day onwards. So there are various formulations that the court can come in, assuming that they find that the procedure to be wrong. But
No,
if
but
the court may also say that no, what what you have done is upon further reflection uh, is uh, uh, is possibly right, because even if there is some kind of very minor connection with money, even then it can qualify as a money bill. I'm just giving you the possibility. Uh, if a court were to say that, then the government's actions would be upheld.
Hmm.
That may not be likely,
Hmm.
but it's always a possibility.
No, but in case of Aadhaar Act, I'm just taking that one example. Will
Now,
it not
in case
legal?
let's assume that they say that Aadhaar was passed through a wrong procedure,
Hmm.
they can strike down in the act and say it will be inoperative from this day onwards.
Okay.
But they are not likely to thereafter say that everybody who's got an Aadhaar number, you will surrender it, the Aadhaar data will be wiped out, and the clock will be taken back to a position as if Aadhaar never existed.
Yes.
That
That is that is why I was asking you, will it not lead to a legal chaos if everything becomes inoperative and everything is struck down?
it will be struck down. If it is struck down, it can be struck down with prospective effect from the
Okay.
date of the day.
Okay. 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 But Mr. Achari, to you now. Now, what do you think is this tool which is used by the government, and has it been used by the earlier governments also? Now, this is something which was seen as unprecedented. The way Modi government did it, converting the non-money bills into money bills, using the ordinances also, for their political purpose. That was also highly criticized. Now, what is this tool which is really used by the government? And is it legitimate when such criticisms come up? And like what Mr. Hegde said, that this is a big fraud on the constitution. So the governments knowing that this is a fraud, and then also if they adopt it as a tactics, as a tool, so what would one say to this?
Well, we have never done it. I was Secretary General for 5 years, and during my period, there was no occasion when we had to take a wrong decision, because speaker, it is the speaker who decides. Even if the government says that it is a money bill, speaker will independently, because this power is entrusted to the speaker by the constitution to be used objectively and in a fair manner, as per the law, as per the constitution. That means as per Article 110, which says, or which defines the money bill. So if a bill fulfills any of these conditions, and only these conditions, and the bill should contain only these conditions and nothing else, only then it becomes money bill. So it's a very restrictive thing. The speaker has to apply his mind. In fact, speaker means the secretariat certainly examines it and puts a proposal to the speaker, and then he considers it. That is the process. So secretariat examines it, and we examined it, and then we give an opinion to the speaker, and the speaker will apply his mind independently also, and only after that a decision is taken. It is not that the speaker will take a decision merely by the government asking him to take a decision. That is not how it is. Speaker has to apply his mind independently. That is it, because he is performing a constitutional function.
No, but the
Yes.
examples which exist, Mr. Achari, so would you say that probably the speaker did not apply his mind, the secretariat did not examine the things well, and which is why these non-money bills were treated as money bills in Lok Sabha?
But I am not saying anything. I am not accusing anybody of anything. What I am saying is that under the constitution, the speaker has to apply his mind objectively to the bill concerned, and take a decision. Take a decision, and that should be legally correct. That is it. and Speaker is supposed to take a legally correct, constitutionally correct decision on a bill, because you are depriving one House of Parliament of its right to reject or accept a bill. Because under the Constitution, unless a bill is passed by both the houses, then the bill is not deemed to have been passed. So that is the provision. That is what the Constitution says. So here is the case. So there is an exception. That is, the exception is in the case of money bills. So here is a situation where the Speaker certifies that a bill is money bill and then deprives the Rajya Sabha of its power or its right to examine the bill, reject it, or accept it. So then actually it is a very serious issue. And therefore, Speaker has to apply his mind very objectively. And Speaker has to keep in mind the conditions laid down in Article 110 very strictly. So that word only, that is the key word according to me, which the Speaker should always keep in mind when he takes a decision on this.
All right, I'll come to Mr. Hegde now, and then I'll come for the concluding comments to Mr. Achari. That Mr. Hegde, now, can it really, these petitions, can they really spell some big trouble for the government? When, if first we have to see when the Constitution Bench will be formed, then the case hearing starts. So, can it really bring some serious trouble for the government?
Well, with a serious government, it could spell serious trouble. But we have seen this government is not fazed by many things. If, for instance, they were held to have passed a lot of legislation incorrectly, they may very well choose to pass the legislation again. But with the current combination in the Lok Sabha and the Rajya Sabha, it may not be that easy. So that is where we may be going ahead of the game. But if the court were to strike down these bills and say render them inoperative, then there would be a spot of legislative bother given the current combinations in the Lok Sabha and the Rajya Sabha.
Okay. To you, Mr. Achari, your concluding remarks, and then I'll wind up the show. Yes, sir.
Yeah, about this question.
Yes, sir. Yes, sir. Your concluding remarks on how the
Oh
non-money
yeah.
bill have been converted
Well,
into. Yes, sir.
well, we have never faced this situation. At least I was in Parliament for 40 years. We have never faced such a situation where the government says that a particular bill is a money bill when it is not a money bill, and ask the Speaker to certify it. So Speaker's certificate is the most important thing. On the basis of Speaker's certificate, the rest of the proceedings are conducted. Therefore, Speaker's certificate is the most important. And Speaker has never deviated from Article 110. That is, if because you are supposed to strictly adhere to Article 110 and decide the character of the bill, whether it is a money bill or a financial bill or any other ordinary bill. So we have never faced such a situation here, but only this last time such a thing has happened. And naturally, now it is before the court, and the court will certainly look into this particular case, whether that bill or a group of bills or a money bill or not. That the court will decide. And after that, as Ms. Sanjay Hegde has said, of course, it will have prospective effect. Otherwise, it will lead to a lot of chaos. And certainly, if it has prospective effect, at least, the people concerned will learn their lessons.
Absolutely. So we'll have to wait and watch when this seven-judge constitution bench is formed, because CJI Chandrachud has clearly said that I will take the call when I form the constitution bench. So we'll have to wait and watch. Thank you so much, Mr. PTT Achari, Mr. Hegde. It was wonderful having both of you on the program. And one appeal to the viewers who are watching this discussion: subscribe to our channel, send us your feedback, and stay tuned to the Federal.